Hi, my name is Nick Falkides, and I handle corporate transactions here at the Coppola Firm. Today we're going to discuss the basics of buying and selling a business, and specifically the two main types of agreements that are used when buying or selling a business.
What are the two main types of agreements that are used to buy or sell a business, and what is the difference between the two?
The two main types of agreements that are used to buy and sell a business are the asset purchase agreement and the stock purchase agreement. The difference between the two is that with an asset purchase agreement, the buyer is buying only the assets of the business, but not its liabilities. With a stock purchase agreement, the buyer is buying the actual shares of stock or the actual membership interests if it's an LLC, and therefore the buyer takes on all of the liabilities that come with the business.
What are the major points covered by most agreements?
The most important point covered in any agreement is to clearly identify what is being bought or sold. If it's specific assets, they need to be listed. If there are specific items that are to be excluded, they need to be specifically excluded. The second most important point is to clearly state the purchase price and the payment terms. The next thing that usually comes in an agreement is representations and warranties. These are always given by the seller, but sometimes given by the buyer as well. The next portion of most agreements usually deals with covenants. For example, the seller might have a covenant not to compete with the business after the sale. The next clause that you have in most agreements is conditions precedent. So for example, if the buyer is getting a bank loan to buy the business, one of the conditions precedent will be that the bank has agreed to make the loan. The next part of most agreements is oftentimes the most important clause in any agreement. That's called indemnifications. So for example, a seller is going to represent and warrant that the seller has good title to the assets. If it turns out that that's not true, and the buyer makes a claim against the seller post-closing, the seller will be expected to indemnify the buyer against third-party claims. This is often a heavily negotiated clause, and a lot of attention is paid to indemnification clauses in agreements. The last part of most agreements is called miscellaneous, but there's quite often important things that are in the miscellaneous section of an agreement. One of them, for example, is attorney's fees. If one party breaches the agreement, is that party liable for the other party's attorney's fees if there's litigation? So never overlook the miscellaneous section of an agreement.
What is a client's most important role in the process?
The most important role of the client is to clearly identify what is being transferred and what is not being transferred. Another important role for a client to play is to clearly identify and then flesh out and state in the agreement each party's obligations, not only during the transaction, but also before and after the transaction as well. On the buyer side, it is critical for the buyer to perform due diligence on the business to identify missing assets, contracts that cannot be assumed, and other potential risks. On the seller side, it is critical to provide full disclosure on all requested information and to provide all requested information. In addition, if a seller is holding a note in connection with the sale of the business, the seller needs to make sure that the note is properly collateralized or that it is personally guaranteed to ensure that it gets paid in full at the time that it's supposed to be paid.
What are the most common mistakes clients make in buy-sell transactions?
For buyers, the most common mistake is the failure to perform sufficient due diligence on the business. Another common buyer mistake is the failure to obtain landlord consents, for example, if the seller has a lease, or vendor consents, as well as the failure to understand the nature of the seller's relationships with its clients, customers, and vendors. It is critical for the buyer to understand these things and to know which one of these relationships is likely to continue and which one of them is not. For sellers, the biggest issue is the failure to disclose claims, both actual claims and foreseeable or potential claims coming down the road. Another common seller problem is the seller's reluctance or failure to assist the buyer in obtaining the necessary consents. For both sellers and buyers, not informing their attorney of potential issues before they occur can often occur and pose big problems for the transaction. Finally, what all parties need to understand in a transaction is that if contentious issues arise, the parties need to get together in person to resolve them. They cannot expect their attorneys to wave a magic wand and resolve business issues. Business issues are for the business people to resolve. They then instruct their lawyers how the issue has been resolved and make sure that it's written up correctly in the agreement. Here at the Coppola Firm, we regularly assist clients with buying and selling businesses. We'd be happy to help you with your transaction. Feel free to give me a call directly if you'd like assistance. Thank you.